Hello, good evening, good morning, good afternoon, greetings wherever you are. You are watching You and Your Rights, brought to you by Photo Solicitors every Monday from 7 p.m. in UK British time. We come your way with topical issues that might affect you, your friends, your family, or anyone that you love. This evening, we're going to talk about previous breaches of immigration laws and how it affects your future application. Meaning making an application for entry clearance, making an application whilst you are in the UK for leave to remain, or even going ahead to make an indefinite leave to remain application. Some of the breaches that you have made in relation to the immigration law, how it's going to affect you. Please, what I would entreat you to do is to share this video to other people who might be interested or people that might be helped by you sending this particular broadcast to them. Today's episode, I've got in the studios with me one of the top lawyers at Fort Worth Solicitors. He's one of the senior partners of the firm, and I'm very elated to have this individual with me in the studios today because he's very vested in these particular areas of law when it comes to immigration. So, without much ado, um, in fact, I will wait and we will just allow viewers to have the opportunity to share this video to others. So before we introduce our panelists or our guests in the studio, we're going to be right back and we would entreat everyone to share this broadcast to each and every one, your loved ones, so that all of them might benefit from it. So you are watching You and Your Right, and it's brought to you by Fort Worth Solicitors. We're going to be right back. Hello, welcome once again. You're watching You and Your Right, and it's brought to you by Fort Worth Solicitors. Without much ado, I would go ahead and allow our able guest to introduce himself. And I'm sure that so many people would have seen his face before, but it is right for him to introduce himself to everyone. Probably there might be people who are watching us the first time. So, please, Mr. Guest, can you introduce yourself to our distinguished viewers?
Thank you very much, Lawyer PK. I'm very honored for your introduction. I must say that I'm pleased about today's topic, and for those who are joining us for the very first time, my name is Lawyer Daniel Koi from Photos Listers. I'm one of the directors, and I'm pleased that today we are here once again to deliberate on one of the areas of law that we practice in, which is immigration issues, talking about previous breaches of the immigration law and how it can affect visa applications. For those of you who are not or who do not know what we do at Photo Solicitors, we deal in a number of law areas such as family. We deal with wills and probates. We deal with civil litigation. We deal with employment matters, and we also deal with immigration and asylum applications. When it comes to immigration, we deal with every aspect of immigration from corporate or business immigration to family and private life matters to detention matters to anything to do with high net individuals who are looking to relocate to the UK. So whether you've got a business, whether you've got an idea, whether you are an entrepreneur and you want to set up in the UK, if you contact Photo Solicitors, you'll be the right people to assist you through the process to make sure the process is as smooth as possible. In terms of my practice myself, I've been in the industry for so many years. It's been over a decade at the moment, and we are happy to serve. We've assisted so many people with so many applications and appeals and judicial review and anything that you can mention when it comes to immigration. And we are happy to once again to be able to come to you on this program to be able to deliberate and to educate you. I must say that whatever we discuss on this program, today's date being 25th of September, is what we know as of today. But we always say this is for educational purposes. It's not something, don't take it as a legal advice. Don't go and act upon it. It's always very important that you seek legal advice before taking any action because your circumstances may be different from what we have discussed. So it's very, very, very important that you simply take this as an educational program and not a legal program that is advising you on what to do and what not to do. So, Lawyer PK, I think I have done enough introduction of myself and the topic today. And if you will lead us on where or the path for us to go, I'll be more than pleased.
Thank you very much, Laura Daniel, for a short, brief, but long introduction of yourself. I really appreciate that. So let's go straight into our program for this evening, or wherever you are watching us from. As we rightly said, it's your previous breaches of the immigration law. What effect will it have on you when you are making future applications, either entry clearance, you are here in the UK and you are making further leave to remain to stay here in the UK? Whilst we were deliberating on this topic, we tried to put it into three sections and we're going to go through it. So, the first section is going to be what actually constitutes immigration breach, because there might be certain things that you might do and you will not even know that it constitutes an immigration breach. So we will first of all look at that. Secondly, we will also be looking at how does that breach affect that future visa application or leave to remain that you will be making in the UK, obviously to come or whilst you are in the UK. And lastly, how should your previous breach be addressed when you are making that future application? So we've done it in these three sections, but we're going to delve into it one by one, and we will educate people. And trust me, there are certain things that you might be taking for granted this evening. We're going to make it very close to you for you to feel like, oh, this breach could affect my future application. You relate to it. So there are certain things that might affect, or there are certain things that will constitute immigration breach. So many of them. We would obviously not go through all of them this evening, but there are some few of them that resonate that we will let viewers know about. So, Lawyer Daniel, can you take us through um, some of the things that we do that would constitute an immigration breach in the UK, or if you want to make an application to come from wherever you want to come to the UK?
All right, thank you very much, La PK. It's very important that before we go into our discussion, we simply understand or we are all on the same page of what we can determine as an immigration breach. Because if you don't know what a breach is, you might not even know what we are talking about and why this can affect you. Because there are certain things that some people might not even understand or realize that it may be considered as a breach. So, for the purposes of paragraph 9.8.1, which is the mandatory refusal if within a period. And when we have basically two aspects that we are dealing with. We have mandatory points for refusal, and then we have the discretionary points for refusal. So there are certain things that you will realize that once you do it, the Home Office have no other option but to refuse any future applications that you do. And there are certain things that when you do it, you may have a discretionary point for a refusal. And we need to look at each one so that when whatever happens, you know what you are dealing with and how to deal with it, because dealing with each one may be different from the other. But there are four key things that people need to understand may constitute an immigration breach. And one of them is overstaying, breaching a condition of permission, illegal entry, okay, or including attempted entry, entry, and then the use of deception in an application. So, in today's program, when we talk about breaches, we are going to tackle one after the other so that people understand what it actually means. So, let's start with overstaying. Overstaying is in the UK longer than permitted by your permission to enter or stay. Comes under paragraph 9.84 and 9.85 of the immigration rules, which indicates that if a person has been given leave to remain and the person overstays for more than 90 days or less, and the overstaying began before 6th of April 2017, that person will be considered to have overstayed his or her leave to remain. So remember that there is a 90 days gap when you are given a leave to remain. It could have happened in the past, and which could affect any future application. So any breaches that happened before 6th of April 2017, whereby you overstayed a period of leave that was granted to you for more than 90 days, this is likely to be considered as a breach under the immigration rules. It could be that you were given a visitor's visa, which was valid for 6 months, or it could be that you were given a visitor's visa, which was even valid for more than 6 months. You have some people who may have a visitor's visa, which is valid for 5 years or 10 years in some circumstances. But we all know that when you are given visitor's visa, which is even valid for more than 6 months, the maximum period or duration that you can live in the UK is 6 months at a time. And for you to be in condo or like live within the conditions of your leave to remain or visa, you have to make sure that you don't stay more than 6 months at a time. So if you had overstayed more than 6 months for a period of time without any justifiable reason, you have not been able to make an application to the Home Office for them to extend it, this will be considered as a breach. And for 90 days, anytime before 6th of April 2017. A person who overstayed for 30 days or less and the overstaying began on or after 6th of April 2017 will also be considered as overstaying. So after 6th of April 2017 all the way to 24th of November 2016, the breach should be 30 days or more. That's when it will be considered as a breach. So if anything is less than 30 days, that will be you might get away with it. Then anytime after 24th of November 2016, then we are only looking at about 14 days thereabout. And that's also very, very important for you to understand these things. So depending on the time of year that you may have overstayed, this is likely to affect a future application. It's also important to understand that we do not encourage people to overstay in the UK under any circumstance, whether it is 1 day or 2 days, because as we speak currently, any any period that you may overstay your leave to remain may be considered as a breach or a criminal offense under section 24 subsection 1b I of the Immigration Act 1971. So it's very, very, very important that you understand that, and any period of overstaying is subject to the hostile environment, which requires employers, landlords, NHS staff to check your immigration status before offering job, housing, healthcare. Moreover, any future applications may be affected, even though you may be granted. They may have a discretionary reason to refuse your application. Then we can talk about breaching a condition of permission, which can also be a breach of your immigration rules. For instance, if you are given a leave to remain in the UK, every leave to remain, so long as it's limited, even for indefinite leave to remain, it will have a condition with it. But most limited leave to remain have more conditions to it. So, for instance, the most significant condition that comes with a lot of permissions is no recourse to public funds. So, if you are given a leave to remain with no recourse to public funds, you should understand that once you have been given that, you do not go and access certain public funds. And if you do that, you are in breach of the condition of your permission. If you are given leave to remain as a student, you have a student visa, you are likely to have certain conditions, such as you not working more than 20 hours during term time. And during holidays, you may do more hours. If that is the condition that comes with your leave to remain, it is very, very, very important you comply with that. Because if you decide to do 21 hours during 10 time, you want decide to do 40 hours during 10 time, you are in breach of that. And for that reason, you may be punished, or your leave to remain may be curtailed, or you may have implications which will be coming into once you are in breach. But that is something that you need to understand can affect make. So the conditions that comes with your leave to remain is very, very, very important. Apart from that, there may be certain things that you may not even be aware of. For instance, somebody may come in as a family member of an EU national, maybe adult dependent of that EU national. Once the person has arrived in the UK, the person will think, well, I'm an adult dependent of my on my dad, and it's because of that I was given my leave to remain or leave to enter, and I'm here. I've been given 5 years. I've been given permission to work, and I'm working now. My dad is working. Why do I have to live with my dad? Because if I stay with him, it's going to affect any benefits that they are enjoying. And for that reason, I want to leave the property and go elsewhere. You need to understand that you were given your leave to enter or your residence permit based on the fact that you argued or you portrayed yourself as being dependent on your dad. And once you have moved out of the property and gone elsewhere, that will not be considered as being in compliance of your limit or your leave to enter. And for that reason, this can also affect you. It can lead to your leave to remain being curtailed, being cancelled, or being taken away. So that is something very significant that you need to know you cannot be doing. So there are so many elements that come with it that people need to appreciate that can affect their current leave to remain, and people need to comply with it. Then there is what we call illegal entry, which means knowingly entering the UK without leave to enter, unless of course leave is not required. So because you are a person of British citizen, or you are from a country where you don't require any, you are from a visa country, a visa free, non-visa national, so you don't need a visa to arrive in the UK. Even that, we expect that at the point of entry, you will be given a stamp in your passport that allows you to stay in the country for 6 months or so. So if you entered without getting that necessary stamp in your passport, you may even get into trouble. So knowingly entering the country without leave to enter is something that is a criminal offense under Section 24 of the Immigration Act 1971 as well. So it is very, very, very important to understand that knowingly entering the country may affect you. You could be detained, you could be convicted, or they can take you to wherever for a criminal conviction. So that's something we need to know. The last point, or the last thing that I want to discuss as being in breach of the immigration rule, is obtaining or seeking to obtain leave to enter or remain in the UK, or to avoid, postpone, or revoke an enforcement action is an immigration offense under Section 24A of the Immigration Act. So this may be done by lying on an application for a visa. You are making an application, you know what you are saying is not true. You are deliberately avoiding, or you are being deceptive. That is against the immigration rules, and that can be classed on its own as a breach of the immigration law. This can be a basis for further refusal. Sometimes it may not necessarily be lying, but you concealing information from the home office or from in an application which you know may affect your application. Patrick, it's very, very important I dwell much on this, because there are sometimes people may make honest mistakes that can affect their application when it comes to how previous breaches may affect your application. So sometimes people will be making an application, the person have been refused previously, maybe 3 times, 4 times. The person attempted to make an application to come to the UK, the person made a mistake, or the person was refused. When making a current application, the person may have forgotten the dates, so the person may disclose three of the refusals instead of having to disclose four of them. And for this will be determined as deception. And I'm aware of scenarios and cases where this has affected people. So it's very, very, very important that when you have to make an application and you have a colored immigration history, you have made previous applications which have been refused, you don't remember the dates, you are not too sure. It's very important you seek you do a, what we call subject access request to obtain your file from the home office to be sure about the application that you are making so that you are not accused or they don't tell you that you are deliberately making a deceptive application, or you are lying, or you want to conceal information from the home office. So it's very, very important. If you are not too sure, you are not too keen, you know there was a refusal, you need to deal with it. Whilst I'm on it, I need to also emphasize that if you are a person who is under the age of 18 years, you cannot be determined, or you cannot say that you've been in breach of immigration rules. So if something, any of these things happen while you are a minor, while you are a child, you cannot necessarily be there cannot affect any future applications, because when the incident happened, you were a child at the time. However, if maybe you have been in the UK before, even at the time you were a child, you were in breach of an application, or you are in breach of your conditions of stay, and you are now an adult, you are now 18 years, you are making an application, and they ask you, have you ever been in the UK? And they say, no, you have never been in the UK. This may be a basis of refusal simply because you are concealing information. It is not simply because you were in breach of the immigration rules whilst you were a minor, but you are being refused simply because at the age of 18 or more than being an adult, you are concealing information that may have happened in the past. So we need to be very careful. That's why we say when you are not too sure, speak to somebody who can deliberate or look at your issues and advise you on what you ought to do. Lawyer PK, at this stage, I think having been able to explain the basis and the reasons why somebody may be in breach, or what may be considered as a breach of the immigration law, it is important we also tackle how previous breaches of immigration law can affect an application. And at this stage, I will also want you to explain some of the implications of the breaches to our listeners, for them to understand why it's important they get the application right all the time, and then they will appreciate why we are on this, or we are hitting on this topic so much this evening.
Thank you very much. As obviously, you've mentioned a lot about what constitutes a breach of an immigration rule or immigration law. We will go ahead to look at how does it affect your visa application, being it entry clearance or leave to remain whilst you are here in the UK. So, some of the previous breaches might also be labeled or might be mentioned as, for example, you've absconded. They gave you a bail. You were apprehended previously. They gave you a bail and you absconded. It is a previous breach that the effects will be mentioned later on. You've used NHS. Your leave to remain didn't allow you to use NHS. For example, most visitors visas, you are not allowed to use NHS, and you use NHS. It is a previous breach of your immigration condition whilst you are here in the UK. Again, people who involve or people who get themselves involved with what we call marriage of convenience. I must stress that people don't take this thing very serious, because we know that there are so many people that the Home Office have accused them that they've involved themselves in marriage of convenience, or we call a sham marriage, and they've just left it like that. According to the immigration rules, this is a breach of your immigration, or a condition of your leave to remain in the UK. People need to be aware of that. That previous breach, and the fact that you didn't defend when the Home Office alleged that you've involved in sham marriage, or you've involved in marriage of convenience, and you kept quiet about it, you didn't challenge it through the courts, and you kept quiet, that will be classified as an immigration breach. And the effect of it is that your subsequent or your future applications that you are going to make, the Home Office will have records of that. That, for example, you came to the UK with a visitor's visa, you were not meant to work. You came in as a visitor, you worked. Therefore, that previous breach would amount to an effect that I will be talking about later on. There are even other people who come to the UK, or who are in the UK, and they make frivolous applications. When we say frivolous application, there they are the applications that the individual knows that the application will be refused, but because they are in the system, they're just making the application just to keep themselves in the system. Today you are hearing that that is also a breach of your leave to remain. Even if you've got that leave to remain or not, the Home Office will take it as a breach of a condition whilst you are here in the UK. So probably you would have exhausted your visitor's visa, you would have exhausted your student visa, you wouldn't even have been at the point to make the correct application, but you just wanted to make an application just to be in the system. The Home Office will use that as a breach of your condition. And the effects, the tremendous effects, dependent on the specific type of application or the specific breach that you made, you might be banned for 12 months. Specifically, you might also be banned for 10 years, depending on the type of breach that you've committed. Say, for example, if you came to the UK and you you were in one of the, the elements of constituting a breach. For example, your leave to remain expired, and you lived here for more than 90 days prior to 2017, or after 2017, 6th of April, you could have lived here for 30 days without any issues, and you left by yourself. Maybe you came with a visitor's visa, you came with a student visa, or maybe even if your spouse visa expired because of a reason, you were divorced, but you lived here for that 30 days, say after 6th of April 2017, and you left, you will be banned because there is a previous breach. After 30 days, 31 day, you would have breached your condition as a person who previously had lived to remain in the UK. If you went voluntarily, you will be banned for 12 months. So you don't venture to make any subsequent application. But as we're going into, there are some exceptions, but there are mandatory refusal for specific type of application. If you have breached some of the conditions that I've just mentioned, absconding, working in breach of your condition, using NHS, you've involved in marriage of convenience, and you left after 31 day, you will be banned for 1 year. If you went voluntarily, you purchased your own ticket and you went. However, if you spent more than 31 days after 1st of or April 2017, or before April 2017, 90 days, and you were absconded, sorry, you were apprehended and you were sent by taxpayers' money, you will be banned for 10 years. Even if you use deception, say for example, you use fake bank statement, you use fake information, the information that you ought to have provided as part of your application, you deliberately or indeliberately didn't provide that information, and it is deemed as a breach of your condition through deception, you will be banned for 10 years without making specific type of application. And most of the applications that you will be banned to make within that 10 years are, for example, visitor's visa. Immediately you are deemed to have previously breached an immigration condition, within 10 years, whatever visitor's visa application that you make will be refused. Student visa applications, they might be refused or they may be refused. When it comes to most of the skilled worker visa applications, they may be refused because you've breached an immigration rule or you've breached a condition of your leave to remain whilst you came to the UK. But exceptionally, there are some of the leave to remain that there might be a leeway in the home office rules. They say they may, it is not mandatory refusal. They may be refused dependent on the individual specific circumstance. For example, if you are making an application based on your family life, that is the family migration. Say, for example, you came to the UK, you breached an immigration condition. Say, you were not supposed to be working, you're a student, you're not supposed to be working 20, more than 20 hours. You worked 20 hours, you came as a visitor, you're not supposed to be working, and you worked, used NHS, and something happened, and you were apprehended and you had to be sent home. Typically you will be banned for 10 years. But if you are making an application for family migration, your spouse is obviously um, sponsoring you to come to the UK as a spouse, then there might be a discretion. But as we're going to go into details with how uh, previous breaches are need to be addressed in the application, subsequent application that you make. We will be talking about that. All these things need to be dealt with appropriately. Other than that, although it is a discretion when you are making a family migration, the entry clearance officer or whoever is dealing with your application, if it is not explained properly, that individual might decide to refuse your application. There are some of them too that the condition or the circumstance that you found yourself at that point, there wasn't anything that you could do than to breach the condition of your leave. For example, someone would have come in with a student visa, or let me say a visitor's visa. But at that point, they were supposed to have left. But because of their specific circumstance or because of what they met, they couldn't have gone. Then, with evidence, that individual will be able to show, then there might be a discretion. It might not be a mandatory refusal. But in a nutshell, what people need to be aware of is that the effect on your visa application is normally you will be banned if you breach any of your immigration condition and you left by your own accord after the required duration that we've mentioned. You will be banned for at least 12 months. If you didn't leave and you were apprehended and you taxpayers money to remove you from the United Kingdom, you will be banned for 10 years unless you are making an application for family migration. Either your spouse is bringing you or something of that sort. So I don't know whether Lawyer Dan would have something to add to the effects on your visa application if there are breaches to the
Yeah, I
previous
think
immigration rules.
the sound is come down a bit. If you can, I don't know whether you can hear me, but I cannot hear you
Yeah,
here.
I can hear you.
So
I
if
can
you
hear
can
you clearly.
continue from your end, and let me see if we can resolve it from here quickly.
Yeah, I can hear you clearly.
Can you hear me?
Oh, yeah, I can hear you clearly. Yes.
No, the sound is not working at the moment. Let's see.
Okay,
We seem to be
then
having a bit
then
of
probably
yeah,
then what we would do is that is in fact time for us to have a quick commercial break, and
yeah.
this will be the time that people who have just joined us, greetings to you wherever you are watching us from. We're going to go for a quick commercial break, and when we come back, we're going to deal with some of the issues when it comes to when there has been a breach of an immigration condition and you are making a future application. What needs to go into the application? Things that you might not think about that are important, but from this program, you will know that you need to make the entry clearance or the immigration officer aware of. We're going to be right back. Stay with us for a short commercial break, and you are watching You and Your Right, and it's brought to you by Fortua Solicitors. We're going to be right back. Welcome back. You are watching You and Your Right, and it's brought to you by Fortua Solicitors. If you've just joined us for this program, we've been discussing breaches of immigration law or immigration rules and the effect on your future application. Probably you might not be aware, or you don't even know that previous breaches might affect your future application. We've been talking about it. We've talked about what constitutes breaches of immigration condition. We've dealt with the conditions that you need to adhere to. What if you've been granted a specific type of visa? We've gone into it, and we've also deliberated a bit on how the breaches can affect the visa application that you will make in the future. If you've not shared the video yet, please do us the honors and share the video to other people who might benefit from it. Because as we've heard from the very beginning of this program, this information are for people who are making application to enter the UK and also those who are in the UK. Because when it comes to certain breaches, for example, deception. The deception can follow you up until when you are making your British passport. You might have deceived the entry clearance officer whilst you were coming as a student, whilst you were coming as a visitor by using a fake bank statement. But in future, you would have had the opportunity to make an application that will cement your stay in the UK for you to have an indefinite leave to remain. That deception that you use to obtain the first entry clearance to come to the UK, The Home Office or the immigration rules or the laws allows the Secretary of State to use that deception to refuse a legitimate application that you've made at this point, although it's in the future. That is why this program is very, very important for you to listen, to share to other people so that they are aware of the implications of them breaching the condition of their stay in the UK if they've been given an opportunity. I'm in the studio with one of our able lawyers, Lawyer Dan. I've been deliberating with him on this particular topic. And before we went for that break, we had some technical issues. I don't know whether he's able to hear me clearly now. Ladan, are you? Uh, Maybe you are muted.
Hear me now? Yes.
Yeah, I can hear you clearly now. Good, fantastic. At
Yes.
least we can now communicate. So before we left, we were talking about some of the effects of, for
Mhm.
example, overstaying, the your leave to remain, some of the things that you shouldn't do, the effects, being banned for 12 months, being banned for 10 years, you're not being able to make application within that time, specific type of application within that time, because if you do, it's a mandatory refusal. Some of them too, we were talking about some of them being discretionary when it comes to family migration. I don't know at that point whether you heard everything that I said and if you wanted to add anything to it at that point before we had our
No,
technical hitch.
I think you really tackled most of the issues, and some of the issues, or how do previous breaches of immigration law affect visa applications. And we talked about, depending on the nature of the breach, the effect can be enormous. For instance, whereby you have been in breach of an immigration law, and then you are also making acts or things that could be looked at aggravating. You are absconding. You are trying to find ways and means to frustrate the process, the system. All these things can have effects. So, a typical example is when you are in breach of an immigration rule, and you decide that you want to come clean now. Let's say you have been in UK in breach of you've been an overstayer. You now have met somebody that you want to marry. So you have been advised that the best thing for you to do is, you cannot make the application within the UK. You have to go back home and make an application and come back. However, it also comes to light that you'll be able to make an application once you have traveled back to your home country at your own accord without using public funds. But it also comes to light that you have frustrated the process. You have either presented false passports in the past, you have tried to use different names to obtain leave to remain, you have gone through the legal processes, judicial review, you have maybe debts that you need to pay the home office which you haven't paid, and all sorts of things. These are things that, even despite everything, we know that ideally it should not affect any future application that you are doing simply because of human rights. It may still affect that application because of the aggravating factors that comes to your breach. So it's very, very important we get this thing straight and on time, like we get it right. So sometimes we say, yeah, it may just be a simple thing as absconding, or not meeting a temporary admission or reporting restriction bail condition, or failing to meet the terms of a removal direction after court refusal of leave to remain. So, and this can go a long way to affect future application. There are some times that you may be in breach simply because you have used the NHS, whereby you are not entitled to it. You have been made aware of it. You know that you are supposed to pay back whatever invoice or bill that has been given to you, but you are deliberately refusing to do that. This is something that can affect your application as well, or future applications. So that's something that I think people need to be aware of. So in terms of the effects, I think we can all appreciate the effects at this stage. If anybody is listening to us today, the person knows that, look, if I'm here and I'm in breach of any of these things, this can go a long way to affect any applications that I may have to make. So this clearly brings us to, how should previous breaches of immigration law be addressed in visa applications when you are making any future application. It's important that you understand that, if, as you said, there may be an active re-entry ban that you may have to deal with. And if you have an active re-entry ban, it is probably inadvisable not to make it, or to make an application. It doesn't make sense, because whatever application you may be making, you may be facing a ban. So if somebody has been deported from the UK, and you know that you have a 10-year ban to come back to the UK, and you want to make an application during that period, the possibility is very high. It's very unlikely that they are going to let go. You will be banned. If during that period you have been in breach of your immigration rules, you have left the country, you want to now make a skilled worker visa, or you want to make an application for visitors visa or for student visa, any of the applications under the point-based system, you should know that during that re-entry period, you are going to face problems. Unless you have a very good reason, you have compassionate circumstances surrounding the breach, and if possible, to provide independent, verifiable evidence of these circumstances. For instance, if somebody overstayed their visa because they were caring for a loved one in a hospital, you should be able to provide medical treatment letters and support of this compassionate reason. Or you came to the UK on a visitor's visa and you fell ill. And for that reason, you were not able to return, especially during the COVID 19 period, where a lot of people, there were a lot of disruption in travel and all that. This is something that can be treated as a compassionate reason for your breach, and you will not be penalized. But it is very, very important you are able to explain this to them, to make sure that they understand the processes. You put the evidence in for them to address it. If not, you are going to have an issue. Sometimes there may be a breach of condition or deception. You may be accused of being deceptive in something, but it may not be deliberate. We have seen situations where people have made applications, where the application, they were assisted by a solicitor, they were assisted by an immigration advisor, and maybe there were certain things, questions that were asked, that whilst looking on those documents, you may have overlooked them, and you may have not answered, or you may have not read it properly, and you may have submitted. It may just be an honest mistake that you may have made. It's very, very important you explain these things in your future application. If not, you may even end up getting further banned, because you have you didn't deal with it properly. So it's very, very important that when you've had such issues, you tackle them properly. You if you're not too sure how to tackle it, you may have to seek legal advice from a professional who will be able to advise you or help you to draft a response to it. So this is my advice to people who are looking to deal with these issues. Lawyer PK, at this stage, I don't know whether there may be certain things that you think you may be able to add. For instance, somebody who have overstayed their leave to remain, and may have had one or two bail conditions breached, and the person wants to have met somebody, the person wants to marry the person and go to their home country and make a reapplication. What advice would you give such a person? Because when the person is going away, at the back of his or her mind, is worried that maybe going out of the country, any future application is going to affect him, and he's worried about his relationship status, how long is going. So, how should such a person deal with such an application?
All right, thank you very much. As I touched on it earlier on, there are some mandatory refusals when it comes to specific type of applications that you make. Say, for example, visitors visa, point-based system applications. They are mandatory refusal if you are banned or if you are deemed to have breached an immigration condition whilst you had a specific type of leave to remain in the UK. But there is a discretion when it comes to when you are making an application based on the Appendix FM, that is Appendix Family Migration. There is a discretion to the extent that some of or most of the times when people come in and they breach immigration condition because maybe they've overstayed as visitors, they've breached a condition of their leave to remain as student, they've worked more than 20 hours and they've been apprehended, they've absconded, they've detention, they've they've made so many breaches to their immigration conditions. And when it comes to Appendix FM, that is family migration, because it is based on their human rights, that is their family rights, the Secretary of State has the discretion looking at the specific circumstance. Say the person has come to the UK, they've breached their visitors visa condition, they came, they didn't go back, they've met someone here in the UK, they want to make an application. One of the things that fortress solicitors will help you to do when you find yourself in that circumstance is that we would abuse that law to defend you that, first of all, the type of application that you would want to make, you cannot make that application whilst you are here in the UK because you will be barred from making the application. You are an overstayer. You cannot make spouse visa application whilst you are in the UK. You cannot make use of the Appendix FM whilst you are in the UK. So we abuse this particular circumstance to your benefit that you have no option than to go back to your home country to make that application. Although the breaches, the effect of your application will be blurred in your face. It will be there because I have said it. Lawyer Dan has said it in this particular program that if you breach any of the immigration rules, you will be banned for 1 year. You will be banned for 10 years. So the specific circumstance will determine how long you'll be banned. But when it comes to family migration, because it is based on your human rights, there are laws that will be abused to circumvent the fact that that blanket refusal or that blanket ban for you or for everyone shouldn't be applicable to your specific circumstance. Because one, you cannot make the application whilst you are here in the UK. Two, your relationship with this particular individual is deemed as genuine, durable. The only way you can come in is to make a spouse visa application as an entry clearance. Therefore, you have no option than to go back home and make that entry clearance application to come in. So basically, the effect of the ban, 1 year ban, 10-year ban, or whatever years ban that you would have, when it comes to specific type of application, when you seek good legal advice, you can go home and come back in. But there are specific ones that I've previously mentioned. Don't even attempt to make the application because you'll be wasting your money, wasting your time. Visitors visa, most of the point-based system. But when it comes to human rights applications, 9 out of 10, when the laws are there to back you and you seek good legal counsel, you are able to come back and continue to live here, although you have breached uh, certain immigration rules. Daniel on it. but it is emphatic that I make people aware of it. When it comes to applications, I always say that a specific type of application will be granted depending on what goes into the application. Someone might have breached an immigration condition knowingly or unknowingly. Maybe a deception has even occurred. But if you are making a subsequent application or a future application, and you know that deception or that breach was not a breach that you did voluntarily, or you didn't do it to spite the system, that breach can be explained on your application form. There could have been a reason why you breached that immigration condition. But if you don't seek good legal advice and that condition or that situation is not explained in your future application, the application is bound to be refused. But what you must know is that if it is explained in your future application, the entry clearance officer, the caseworker who is looking at your application, if the situation is explained well in your application form or on your application form, reasonably, that individual might know the reason why you breached that immigration condition. Say, for example, you came in during COVID, you overstayed. You making an application, you didn't say anything about the fact that you overstayed your visitor's visa, but it was within the COVID period. You assume that everyone should know that within the COVID period, all aeroplanes were grounded, people were not allowed to travel, so the caseworker or the entry clearance officer should know. No, it is not like that. It's a blanket refusal. If you breach specific type of immigration condition and you are making specific type of visa application to the United Kingdom again, it needs to be explained. That is why for tour solicitors, we are always there to assist you. When you come to you would want us to assist you, we've got this to just to help the community. You can call us. Your first initial consultation is going to be free of charge. Although it's free of charge, but we make sure that we give you everything that you need. If there is something that we can do to assist you, we let you know. If there are things that you need to put together before you come back, we also assist you. Take advantage of this. Go to our website. You can call us anytime on our telephone numbers 0203 57030. You can call us, book a telephone appointment, book a face-to-face appointment, book Zoom appointment, and we will be able to assist you to make an application to come to the UK, although you have breached an immigration condition in the past. Thank you very much for sticking with us throughout this 1 hour period, and we appreciate your presence on this program. We are not able to mention few people's name because of the screen at the moment on Facebook. But if you are watching us, or if you are going to watch us later on after this program, you have been watching You and Your Right, always brought to you by Fortress Solicitors. This evening, we deliberated on previous breaches of immigration laws and the effect that will have on your future application. Lawyer Dan, unless you've got something to tell our viewers and our listeners wherever they are, I would want us to finish this program on a high note.
Yes, I think I'm very want to thank our listeners and our viewers, and we apologize for any technical hitches that we may have had during today's program. And once again, thank everybody who joined us. Thank you.
Thank you very much, Lawyer Dan, too, for making time for us to deal with this program. Thank you, everyone. And every Monday, as you know, it's You and Your Right, and it's brought to you by Fortress Solicitors. Thank you once again, and we will see you same time next week. Thank you for watching.